Assalamualaikum. Kita mula pukul 2 kan? Are we beginning at 2 o'clock?
Yeah, true, 2 p.m. But our participants are not here yet. We have like 70 participants to come.
Ladies and gentlemen, this event will start shortly. I have a few housekeeping notes to make before we begin today's session. Kindly turn off your microphone to avoid any interruption, and you are welcome to ask questions at the end of the session. Thank you for your cooperation and attention. A very good afternoon I bid to our distinguished speakers of the day, Yang Arif Dr. Muhammad Johan Lee, the Kuala Lumpur High Court Judge, Mr. Rajesh Kumar, Senior Group Manager, Privacy and Data Protection Office, Dr. Reka Dewantara, SHMH, Lecturer at the Faculty of Law, Universitas Brawijaya, Professor Dr. Avinash Danish, Director of Manipal Law School, Manipal Academy of Higher Education, Bangalore off campus, and I also extend a warm welcome to our esteemed moderator, Associate Professor Dr. Shahirah Abdul Shukur, Senior Lecturer at the Faculty of Law and Sharia, USIM. Last but not least, welcome to all of the audiences present here. It is my pleasure to conduct this session. Before we proceed, allow me to introduce myself. I am Imran Haziq Jamali from the Faculty of Sharia and Law, USIM, and on behalf of the organizing committee, International Law Unit USIM, will be your MC today. Dear respected guests, before we officially start our session, to bless our special event today, let us raise our hands to assure the prayers that will be led by Ahmad Amjad Majdi.
الفاتحة. بسم الله الرحمن الرحيم. الحمد لله الذي بنعمته تتم الصالحات، والصلاة والسلام على رسولنا الأمين وعلى آله وأصحابه أجمعين. يا الله يا فعال لما يريد. We express our gratitude to you for allowing us to attend the forum on global overview on data privacy this afternoon. Ya Allah, we ask you for the safety of our religion and the welfare of our body. Oh Allah, Lord of the implementing authority, make the days that we've gone through start with your mercy, continue with blessings, and end with your forgiveness. And also make the days we've gone through with guidance and end with the victory of excellence. Ya Allah, Ya Muhaymin, Ya Aziz, Ya Jabbar, let our effort be a means to enlighten and convince ourselves that the personal safety of either outer or inner is a prerequisite for achieving happiness and excellence in various fields. Oh Allah, grant us faith and strength to face life's challenges during the transition period and in the phase of life in this new millennium. Ya Allah, Ya Farij al-Ham, wa Ya Kashif al-Aqam. Show us guidance and adjust our path to achieve happiness and glory. Let us listen to people who like good things and avoid doing evil things. Oh Allah, bless our life in this meeting and gathering and prevent us from harm and unfortunate events. اللهم اجعل جمعنا هذا جمعا مرحوما وتفرقنا من بعده تفرقا معصوما ولا تجعل اللهم فينا ولا معنا ولا من يتبعنا شقيا ولا مطرودا ولا محروما. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. الحمد لله رب العالمين.
Amin, amin, ya Rabbal Alamin. Thank you, Ahmad Amjad Majdi. Honorable guests, ladies and gentlemen, I would like to extend a very warm welcome to all of you for your participation in our forum entitled Global Overview on Data Privacy. This event is organized by the International Law Unit, University Science Islam Malaysia, in collaboration with Manipal Law School. Nonetheless, we came up with this event as we are enthusiastic to hold activities and events, especially for USIM's law students and around Malaysia. We appreciate you for taking the time out of your busy schedule to join us today. We hope you will find this program we have lined up for you to be fruitful and engaging. Dear audience, I would like to seek your kind cooperation to mute your microphone. The audiences may also ask questions to our special panel today during the Q&A session. And now, I would like to call upon Associate Professor Dr. Hazmi Rusli, Head Coordinator, International Law Unit, USIM, Faculty of Sharia and Law, to deliver his opening remarks.
Assalamualaikum. Good afternoon, everyone. It's so good to be here. I would like to welcome everyone to the Global Overview on Data Privacy 2024. And this is a collaboration. I still remember I had this meeting with Prof. Ella a couple of months ago with Dr. Zhu to make this a reality, and it becomes reality today by having this event today. So on behalf of the International Law Unit, the organizing committee of this webinar, we are very, very grateful to have great speakers today that can share their knowledge and experience. We are very grateful. And I would like to mention that today we are in the presence of Yang Arif, Dr. Johan Lee, High Court of Malaya, the Judge of High Court of Malaya. And then we have Mr. V. Rajesh Kumar from Senior Group Manager, Privacy and Data Protection Office, Infosys. Dr. Reka Dewantara, my friend from Universitas Brawijaya, so good to have you here. So we have a mixture of 3 experts from 3 countries. And I'm pretty sure maybe Yang Arif, Dr. Johan Lee may have forgotten me, but I actually dealt with him a decade ago when he trained Muting team of USIM. That was a decade ago. So good to have you here, Yang Arif, Dr. John Lee. We are very grateful to have you here, and also our friends from India, from Indonesia. And then this session is moderated by Associate Professor Dr. Shahira Abdul Syukur, my own sister. She has always been helpful, very knowledgeable in cyber law. If you wish to do your master's or PhD, I think she's the best person to to become a supervisor on this field of law in University Science Islam Malaysia. And I hope you will enjoy this event and find it useful and informative. I hope you also learn something, especially for students, learn something new and gain new perspective on data privacy. We have to remember that today we are in the presence of 3 great speakers, Yang Arif, Dr. Johan Lee from Malaysia, Mr. Rajesh Kumar from India, and Dr. Reka Dewantara from Universitas Brawijaya. Gather as much knowledge, gather as much experience from them. And then I welcome everyone to our first event with Manipal Law School. I'm pretty sure Prof. Ella is here. Thank you so much for making this a reality. And I believe this will later be a stepping stone for a greater collaboration between USIM and Manipal Law School at Bengaluru. So welcome, selamat datang, and I'm passing the floor back to our Mr. Chairperson. Thank you.
Thank you, Associate Professor Dr. Hazmi Rusli. Now I would like to introduce and call Professor Dr. Ella Gorian from Manipal Law School, Maha Bengaluru, to deliver the opening, deliver the speech.
Thank you, my dear. Good morning, good afternoon, everyone. It's a great pleasure and it's a great honor to participate in such an event. We finally have organized it. We had some obstacles, but now we have all together gathered here, and we have the best experts from 3 jurisdictions in data privacy, and I hope that today's event will be very fruitful for all the participants, for the presenters, and for these listeners who joined us on this platform. And now I want to ask the respected Professor Dr. Avinash, Director of Manipal Law School, to say a greetings word to the presenters. Please, Dr. Avinash.
Thank you, Dr. Ella. First of all, I must congratulate all of you to make it a great success. I know it's not that easy to collaborate, deal with different partners in different jurisdictions, and especially with law professors. We are different. We always have our own great ideas. So, what I believe that this collaboration uh, as a webinar should be the starting point. I strongly believe that we have good collaborations with American, European, and Australian professors, but we rarely work with each other on different areas. We have a lot of similarities in our socio-economic structure, and our rules and regulations can be inspiring and learning phase for all of us. However, in last 50, 60 years, because of the colonization and decolonization process, somehow we believe that yes, we need to either see the US model or the European model or maybe UK model. Okay. I think we need to change this mindset now. I'm not saying that we should not look those models. We should try to understand them. Very good. But at the same time, I think we need to look our neighbors, because historically we are connected with each other, and we share a lot of social and historical connections. So I have no idea about Malaysian law right now. I must admit my ignorance, that this is my highest level of ignorance, that I know more about UK, US, or American laws or European laws than my neighbors' laws. And considering the future of the world, definitely there is no doubt the 21st century will be led by us. This 21st century belongs to us. So I think this is the time that we law professors should also contribute in collaboration and try to understand what is happening in our countries, what we can learn from each other. Maybe in your country, you are following a very good model or a good approach, which India can learn, and vice versa. Okay. I think if we think in a very open manner, it will be great for legal fraternity as well as for our societies and for our countries to find viable solutions. I always tell my friends that, why don't we look something what is happening in South America? Because South American countries, societies, they are also like us, Africa. Why we are not looking at African countries? So I'm not anti Europe or US or the developed countries. What I'm trying to say that this is the time when things are happening in our favor. Things are happening in our favor. At least in last 300, 400 years, I can say that our countries are having best time right now. So we are a very lucky generation who have seen the downside of our countries, like 30 years back, what our countries were. And now today in 2024, and we know that how our countries are going to grow and where they will be by 2040 or 2050. So it's a very unique and lucky generation. We have seen good, bad, everything. So my thought process as a director of Manipal Law School is that the main responsibility of law school is not only to teach students. That's a minor responsibility. Students can learn without us also. Now there are a lot of softwares, lot of certificates program available. What is our duty? Our duty is to help students so that they can serve the society. At the same time, we should also collaborate with industry people, with the government, with our counterparts, with our neighbors, and recommend good policies to our government, our judiciary. So my doors are always open as a Manipal Law School. I would be very happy to invite anyone who is interested to come to India for a minimum 3 months. We have a policy that if you want to come to India, Manipal Law School for minimum 3 months, we will take care of your air tickets, your accommodation, and minimum $2,000 per month. And our objective is that we want to collaborate for research, teaching, and idea generations. So with these words, I think again I go back to Ella. Ella, thank you very much. Ella is our first international faculty at Manipal Law School. This year we are hiring 2 more international faculties full time. So we take people full time or part time also. They can come 3 months, 4 months, 5 months as per their availability. Okay. So I'm looking forward to receive you, host you in India, and whenever I have some time, I love to visit your countries. I think I never visited your countries. It's a very sad. I think I visited more the western part. Now, but I think I need to explore our neighboring countries and understand them and learn from them. Thank you very much.
Okay, thank you, Dr. Ella Gorian, and thank you so much, Professor Dr. Avinash Danish. Now, without further ado, we are pleased to have Dr. Shahirah Abdul Shukur as our respected moderator to begin the session. Thank you.
Okay, thank you very much. Our MC today, Mr. Imran Haziq bin Jamali, our respected speakers, ladies and gentlemen. So, good afternoon, okay, and a very good day. It's a great honor to be the moderator for today's session, Forum on Global Overview on Data Privacy 2024. We are still in January, and today is the last day of January. And we are witnessing in Malaysia our new king being appointed today, inshallah. Okay, and on behalf of the International Law Unit, Faculty of Shariah and Law USIM, University Science Islam Malaysia, in collaboration with Manipal University Faculty of Law, we would like to welcome our respected speakers today, and also ladies and gentlemen, to our session on an interesting topic, an emerging topic on global overview on data privacy 2024. So we have a great speakers today. Okay, our first speaker will be Associate Professor Dr. Reka Dewantara from Faculty of Law, University of Sriwijaya. Our second speaker will be Mr. Rajesh Kumar, who is the Privacy and Data Protection Officer from Infosystem Limited. Okay, our third speaker, our Honorable High Court Judge, Yang Arif Dr. Muhammad Johanli. Ladies and gentlemen, okay, on behalf of the Faculty of Shariah and Law, as a moderator today, I would like to congratulate also International Law Unit in organizing a session on interesting session on privacy, forum discussion among 3 countries, Malaysia, India, and Indonesia. So without further ado, okay, we'd like to call upon our Associate Professor Dr. Reka Dewantara. But before that, let me introduce a little bit about the Associate Professor Dr. Reka Dewantara, who is now a law lecturer in Sriwijaya University, Faculty of Law. His specialization is on business law. He has wrote an extensive books including on privacy data in Indonesia, and he has also an extensive on teaching and research, particularly on privacy and an emerging area as I know in Indonesia itself. So all speakers, you are given about half an hour, okay, to share your point of view, okay, on perspective of data privacy. So we will have the first speaker from talking from the perspective of Indonesia, and then our second speaker, Mr. Rajesh Kumar, will be speaking from the perspective of India. Even though actually when we talk about internet, there is no what you call specific jurisdiction actually. Okay, and last but not least, we're also going to listen from our Honorable Judge, Yang Arif Dr. Muhammad Johanli. So I would like to welcome on behalf of the organizer, Associate Professor Dr. Reka Dewantara. Okay, the floor is yours. The platform is yours, Doctor.
Okay, thank you, Professor Dr. Syahira Abdul Syukur. And Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, and the Honorable of Professor Hasmi and all of the committee, and for all of the distinguished speakers. Okay, may I share for the presentation? Okay, I will present about the epistemological evolution of the personal data and the data protection for the discourse. Because we have been know that there are two differences, there are differentiation between data privacy and the data protection. I think for this era, we've got the final evolution of human is from the Homo erectus into the Homo informaticus. I take from the Gregory and Mendel. He said that we must to provide about the firmness of the subject before we discussing is about he has some book about the history relations for a general theory of law and technology. He said that the rapid and advancement of the technology is not risk-free. This risk often lead to the new problems and new disputes that must be responded by a legal system. So the utilization of the information from data and big data, including for the data collection activities, data crawling, and data behavior analyzing. So the data should be monetized and evaluated in financial indicator before being able to become a competitive value as a business model. We know that in this era, in industrial revolution, all of the system, include of the data, have been disrupted. If I want to take from A until Z, the A is about the artificial intelligence, B is about the blockchains, C is about the cryptocurrency, and etc. So the disruption of the all of our life, include the data, have been make some changes of our life. Another one is called the internet. The internet is here and will continue to grow. There are a lot of new applications and some technologies, and we'll have to still trying for find about the right of the internet and of the governance models. And the second one is called the right business models. So the growth of the internet, there will be the three questions in our minds. The first one is, what is the most important things for the last 40 years? So the answer is the data. The second one is, what is the most important things in the next decade? So the answer is the data. Big data, privacy, and the protection. This is the three things that must be make some new interpretation, not only for our regulation, but it's also if we want to make some translation about the what's data, what is privacy, and what is the data protection. So if you want to, if the question is the things that has evolved in a surprising way, so the answer is the data, big data, privacy, and the data protection. So if we use the philosophical approach, it's called the ontological aspects. So we must focus on of the two things. The first one is called what is the being and what is the existency. So these two words has two impact if we want to make any regulation or the norms, because norms must be made is based on the principle. It's the basic of the norm, and the principle must be based what we call it the value. But sometimes the person have been forget about what is the value. But one thing's in value that must be made some concretization if you want to make the norms is called the ethics. This is the first one, or we can call it the one of the branch of the philosophy that must be made some concretization if we want to make any norms about the data protection and the data privacy. So the legal relationship is one of the standard or some variable, because in cyberspace, I think this is some essentially of a form of networking and relationship that will create an interconnectedness and interdependency. And as a legal subject, we know that the first one is called the person, or in Netherlands is called the naturalis person. This is person as a human. It can be born, it can be eating, he can make any activity in his life, and etc. And the second one is called the artificial person, or in Indonesia is called the reh person or badan hukum. This is as a legal subject. Because in cyberspace and internet, if there are, we will use the data of the naturally person and the reh person as a legal subject. So we must think about the fundamental change about what is self and what is the identity. So we can use this phrase self and identity as a privacy if you are a human or you are a reh person. And then the third one is called a place. Because in the internet or in cyberspace, the term of the place, this is an imaginary space. Maybe we can use the virtual, or we can use the augmented reality, and etc. This is the space inside of the computer. So I think we can make an interpretation that very different from real space, and this is has some limitation for geopolitical and legal constraint. But how about the cyberspace? And how if we use the processing of our data privacy? Is there any limitation for the space? Is there any limitation if we use the data privacy from another person, that the data is used for the transboundaries or cross-border cooperation, or the transporter of the platform? Because not only for the person that have been work, but I think our student is always use all of the e-commerce platform. So if they are agree about the tax wrapping agreement, and sometimes they use the cryptocurrency as the digital money if you want to make some any transaction. So I think the place in cyberspace and the platform of the e-commerce, this must be has any limitation for geopolitical and for the legal constraints. And then the second branch from the philosophical is called the axiological aspect, or the aspect of the value. The focus of the axiological aspect is focused on its usefulness or the utility. In law, we've got some theory from the Jeremy Bentham as the utilitarianism. He said that if you want to make any norms, so it must be make the greatest happiness for the greater number of people. So he called it the norm. If the norm cannot make any utility for all of the people, cannot make any the greatest happiness for the people, so this is not cannot be called as a norm. So for the axiological aspect, for the cyber law, internet, and the data privacy, we can say that is there any question about how the cyber law can be prepared for the legal judgment at both micro and the macro level? It can show that the law in virtual activities in the cyberspace, it can make any recommendation, interpretation at the countries for the legal rules, such as in Indonesia, India, Malaysia, and etc. So this is regarding the interpretation through the finding of the electronic evidence. SD, the data processors, or SD, the data controller, and etc. So the elimination of the apparent contradiction in a country legal system, so we must make any critical analysis of the just decision for the purpose of jurisprudence. So it can be used as a guide for the other judges when he faced with similar or similar cases. So what is the evolutionary epistemology for the data privacy? So the evolutionary for the epistemology refers to three different topics. The first one, we can say that the evolutionary is about the biological evolution of the cognitive mechanism in animals and humans. The first evolutionary is used if you want to read or you want to make some practice in biology and etc. And second one, the theory that knowledge is safe in evolution through the natural selection. And the third one is the study of the historical discovery of the new abstract entities, such as for the abstract numbers or abstract values that will invariably proceed individual acquisition and use of the abstraction. So the epistemology of the knowledge or the methodology that we will use is we will use the third one to know about what is the methods of the data privacy or the methods of the protection of the data. So the epistemology evolutionary distinctive is that has the two features. The first one is the idea for the empirical testing alone doesn't justify for the pragmatic value of the scientific theories, but rather that the social and the methodological process select to support them theories. So it can be close fit for if you use for analyze for the problems. So the mere fact is that the theory, it has been survived for the most rigorous empirical tests available, that in a calculus of probability doesn't predict for the ability to survive for the future testing. So what is the current state of the data privacy and the data protection? If we use the three branches from the philosophy of law, there are some integrative in terms about the ontological. If you want to know the meaning of something or things, the second one is epistemological, and the third one is the axiological aspect. The ontological is used for the substantial study of the data privacy and the data protection. Because in Indonesia, in the Data Protection Act, it has differentiation to make any meaning of the data. If I made some comparison with the GDPR, there has a lot of meaning of the data. And then the epistemological is to obtain the truth with the methodology that inherent in it. And the third one is the axiological. This is for praxis and usefulness, or we call it the practice within stuff. So there are, if you read the books from the Jeroen Ether, the title is The Ethics of the Data Privacy. He read about the two different moral arguments for the data privacy. We can use it, this book is used the ontological aspect from philosophy of law. The first argument, for a harm-based approach to data privacy, it claims that data privacy is justified in as far as it protects us against harm. So I disagree with this claim and argue that this approach is undermined by the unreliable concept and prediction of harm, especially in a rapidly changing for the technological context. I have been saying that a lot of information and technological in our lives have been disrupted. So the second one, the data privacy deserves protection in as far as it constitutes a unique and necessary context for the protection of a fundamental liberal value. So the principle is called the principle of respect for each and every person. So the method that I propose for, if we want to managing for the data privacy, is derived for the second argument. Rather than we want to try to predict and manage harm, we hardly understand. So we need to define clear ethical boundaries for the processing of the personal data. How? I can say that we must use to deliberating for moral value as ethics. We wish to uphold in relation to other interests and for the practical concerns. So I think the real question is how we can do the envision for a good life in a world largely defined by the technology now, and in our techno-social for the future. So what is privacy? Privacy is a basic right that shall be protected. There are, I have 4 regulations that have been regulated, make some meaning, make some interpretation about what is the privacy. The first one is the UN Universal Declaration of the Human Rights. The second one is the Universal Declaration on Bioethics and Human Rights in 2005. The third one is the European Convention for the Protection of Human Rights and the Fundamental Freedom of 1960. And the last one is called the Arab Charter of Human Rights in 2004. Okay, I will discuss this one by one. For the first one, in the United Nations Universal Declaration of Human Rights, in Article 12, it has been regulated that no one should be subjected to arbitrary interference with his privacy. No one should be. So this is, we must write it in bold. No one should be subjected to arbitrary interference with his privacy, family, home, or correspondence, or to attacks on his honor and reputation. So everyone has the right to the protection of the law against such interference or attacks. And then in the Universal Declaration of Bioethics and Human Rights, in Article 9, say that the privacy of the person concerned and the confidentiality of the personal information should be respected, to the greatest extent possible. Such information should not be used or disclosed for a purpose other than those for which it was collected or consented to. So we can use this regulation as the basic norm for the protection of the data or the data privacy. And then in this article say that it must be consistent with the international law, in particular international human rights law. And then in the European Convention for the Protection of Human Rights and Fundamental Freedoms in 1960, in Article 8, it said that everyone has the right to respect for his private and family life. Everyone has right for his home and his correspondence. So there shall be no interference by a public authority with the exercise of the right, except such as in accordance with the law and is necessary in democratic society in the rest of national security, and etc. So it must be the regulation that the protection about the privacy, about the family, home, and etc. is the rights for all of the people. And then in Arab Charter in human rights, in Article 21, it's so that no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence, or to unlawful attack of his honor and reputation. And everyone has a right to the protection to the law against such as interference or attacks. So this regulation is the basic regulation that based from the ethics of the value of the humans. And then in Indonesia, in our constitution, in Article 28G, number 1 of the Indonesian Constitution have been amended. It said that every person has the rights to get protection on his personal or privacy, family, honor, dignity, and properties under his power, and has the rights to feel secure and to get protection from fear of any threat in order to do or not to do. That's something related to their fundamental rights. So if we base on the theory from Hans Kelsen, from Stephen Bow theory, he said that the Constitution is same as the grand norm. Or the Hans Nawiaski in his book said that the Constitution is seems like the fundamental norm, because it has some regulation or regulate about the fundamental rights of the people. So data privacy is the rights for every person in this world to get the protection. So what is the scope of privacy? I take this from the Professor Abu Bakar Munir and etc. His book is about the data protection law in Asia. He read about the 4 scopes for the privacy. The first one is called the information privacy. Information privacy is involved with the establishment of rules governing for the collection and handling of personal data, such as for the credit information and the medical records. And then the communication privacy. This will covering about the security and privacy for mail, telephone, email, and another form of the communication. The third one is called the territorial privacy. It's concerning for the setting of limit on intrusion in domestic and other environments such as the workplace or the public space. And the fourth is called the bodily privacy. This concerning protection of the people's physical being against for the invasive procedures, such as for the drug testing and the cavity of the cells. So the Barack Obama have been said that the protection of personal data is as the information privacy. Barack Obama said that the open information platform of the 21st century can also tempt for the institution to violate the privacy of citizens. the dramatic increases in computer power will decrease in storage costs and huge flows of the information that will characterize for the digital age bring enormous benefits. But it can also create for the risk of abuse. So we need sensible safeguards for protect privacy in this dynamic new world. He said again that we disagree for this privacy is not relevant or desirable in this sensor-driven, social everywhere, big data world that are heading for the world. But people today expect for strong privacy protection because they are increasingly aware of and concerned about the digital trails they leave behind online, and indeed there's plenty of evidence that people still can deeply about privacy. That's the break of privacy. So what is the personal data? There are some phrase or some nomenclature that we will use about the personal data. Personal data is any information relating to an identified or identifiable for the natural person. So the identifiable natural person is one who can be identified directly or indirectly. So this will be the particle for reference to identify such a name, for the identification number, your location data, your online identifier, and some factor for the physical, physiological, genetic, mental, economic, cultural, and some social identity for that natural person. And then what is the processing? Processing is the any operation or set operation which have been performed for the personal data or on set of the personal data, whether this will automatic for the collection, recording, organization, structuring, and etc. So if you use the data protection, we must make some any regulation in our norms about the what is the data processing, what is the limitation. So who will has the responsibility, and then who will be the data protection officer. Between the data processor, the another one is called the controller or data controller. This is the natural or the legal person, the public authority, the agency, or another body that will alone or jointly with others for the determines the purpose and means of the processing or the personal data. If you use the data, there are some, it's called the pseudonymization. This is the processing of the personal data, that the personal data can be no longer be for the attribute for the specific data subject without the use of the additional information, provided that such of the additional information is kept for separately, and this is the subject for technical and organizational measures to ensure that the personal data is not attribute to an identified or the identifiable for the natural persons. And then the data profiling. This is the any form for automatic processing of the personal data that will consisting of the use of the personal data for evaluate for the certain personal aspect relating on natural person that will use for the performance at work, economic situation, health, personal preference, interest, reliability, behavior, and of the movement. Okay, so what is the main principle of the personal data protection? I take this from the GDPR. There are some principles of the personal data protection. The first one is called the lawfulness, fairness, and transparency. Second one is purpose limitation, data minimization, data accuracy, storage limitation, integrity, confidentiality, and security, accountability, data protection by design and by default, and the processors. So what is the lawfulness, fairness, and transparency? So this principle can be divided into three obligations. is for process for the personal data lawfully, for process such data fairly, and process the personal data transparently. So what is the purpose of the limitation? It requires that data shall be collected only for the specific, explicit, and legitimate purpose, and not processed for any manner since incompatible for those purpose. And the data minimization, this principle is essentially obligates for the controllers to obtain and use only those pieces of information that are necessary for the control purposes for processing for that information. In order to comply with the data minimization principle, the organization are required to ensure that their processing of the personal data is adequate, relevant, and limited to what is necessary in relation to the purpose for which they are processed.
Sorry to interrupt, Dr. Reka. You have about 2 minutes.
Okay, thank you, Prof.
Okay. Sorry to interrupt.
Okay, it's okay, no worries. Okay, there are some principle that must use or make some forget decision if we want to make any regulation about the data privacy and the protection of the data. And the important thing of the principle is called the integrity, confidentiality, and the security. Because confidentiality, maybe some countries haven't make any same meaning about what is confidentiality and what is the security. The integrity and confidentiality principle requires that the personal data must be processed for ensure for the appropriate security of the personal data, including for the protection against unauthorized or the unlawful processing and etc. Okay, so what is the challenges for the implementation of the data protection and data privacy law? So the good regulation means good in terms of the regulatory design, regulatory delivery, as well as the regulatory inspection. So for the effective, efficient, and coherent of implementation, some measures shall be taken for the countries. Among other, for the socialization, the organizational structures, because in Indonesia there are still no bodies or there are no institutions that has some authority to controlling to make any supervision for the data privacy. And then the finalization of the implementing regulation are very essential. Education and awareness raising are essential for all of the person and all of the nations. And then the last is the self-regulatory approaches shall be encouraged for all of the person and the solution that will make the data privacy from the people. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Professor Dr. Reka Dewantara, for giving an interesting insight on the current development on privacy in Indonesia, as well as introduction to data privacy itself from the international perspective, from the human rights perspective. So inshallah, we'll be collecting questions. Currently, we have quite a number of questions already for the respected speakers. So shall we move to the second speaker? So before we invite the second speaker, let me introduce Mr. V. Rajesh Kumar, who is currently the Senior Group Manager, Privacy and Data Protection Office at Infosys Limited. Mr. Rajesh is a law graduate by profession and also certified in the field of privacy and information security. And he was awarded as Fellowship in Information Privacy by International Association of Privacy Professionals, United States of America. So, Mr. Rajesh, on behalf of the organizer, we would like to invite you. So, the platform is yours.
A very good afternoon. Thank you. Thanks for both Manipal and the University of Malaysia to extend this privilege to be part of here. And and my other panel members, esteemed panel members, thank you very much. I think my other panel member has extensively covered the concept of privacy and its evolutions and stuff. So in the interest of time, I'll try to, as much as possible, talk from the Indian evolution stage, some of the key drivers why privacy today is very considered to be a very an essential component and what's really happening in this space. Now, you know, technological evolution is one of some of the key drivers. Technological evolution, thus we have seen in the past where space used to be always a constraint, and as a result of which there used to be a limited extent of processing data and stuff, and it used to be in other different modes. But with the technology, cloud, big data, or the Internet of Things, the way we are trying to increase our technological landscape, we are seeing a paradigm shift in the way how privacy is becoming significantly important because of the jurisdictional level where you don't see the data being controlled. Okay, it goes much beyond the borders and any individual's rights, the uniqueness that a privacy beholds for that particular user makes it a much more of a critical or a component aspect when it comes to meeting the needs of the basic characteristics that should compliant for certain things to protect under the laws or under any social cultural value. You know, we had Alan Westwin and other people trying to clearly explain, being the modern father of the modern privacy, the difference between how the privacy had been existing in the physical world compared with the privacy that is currently been existing in the digital world. So digitization was also one of the key driver in driving some of the key aspects that where we right now see many regulations coming across in different jurisdictions. We also saw about the way how trade and innovation. I mean, today, if you look at any multilateral trade agreements or any conversation that we see, privacy being a different, unique subject, but still forms part of trade and innovation. Trade, and as a result of which it really makes a significant placeholder as part of many of the bilateral or any kind of cross-functional, cross-organizational, as well as cross-country discussions. Another key driver that I could potentially look at is cyber crimes, cyber breaches that we potentially uh, where the crimes or the breaches used to start with the intent of conducting a kind of financial gain. But today we see breaches taking place more in terms of violating an individual's rights. It's becoming much more personal in nature, and that really calls for legislations. And in India, if you look at the way back, the Information Technology Act 2000, which is created as part of the model law of the, UNCITRAL, specific, again, it's also part of the international trade law requirement. The IT law was established in 2000. And between 2000 and 2008, where the major amendment came in and we had the IT rules 2011, where specific references from informational privacy, was starting to figure out. And because India being an majorly an outsourcing service provider, market provider, there were a lot of informations which are very confidential in nature, which are personal in nature to end of the end customers, consumers of the clients with whose data being processed in India. That became much more prior importance, as a result of which two exemplary sections were created under the IT Act. One is a section 43A, was coined specifically to grant for any financial damages, but at the same time, we also had section 72A introduced as part of the IT Act 2008 amendment, which also brought in criminal penalties to organizations which are violating contracts when handling personal informations of people who doesn't need to be belonging to within the Indian region, and after this 2011 the rules came in, and in 2012 onwards the journey similar to GDPR, the journey set us very deeper in terms of understanding what is informational privacy. as one of the more component creature, because we had privacy, which is more in terms of search and seizures, way go back in India, but from 1950s, in terms of entering physical space for search and seizure or any issuing or a warrant. It extended beyond it. Privacy was very much contained to certain section, but when the Universal Declaration of Human Rights and the European Union Convention of Human Rights, which esteemed panel member had started getting adopted, and slowly we were looking into different facets of privacy, like the communicational privacy, the bodily privacy. And India initiated its unique identity program, which we call it as an Aadhaar program. Started collating and collecting, processing informations that are not only personally identifiable in nature, but also it was collecting certain sensitive bodily related informations as well as part of that. So that in 2013, APISHA committee was constituted to establish a informational privacy related legislation, and there were many bills. KS Puttaswamy judgment in 2017. But meanwhile, we had our Justice Sri Krishna committee, which had been established, and it came out with its draft bill in 2017 post the case. For the first time, the concept of privacy was much more deeper, not just limiting it to informational privacy, but also covered all the other facets, with many of the judges who were part and parcel, especially the concept of information privacy came into picture, and it showed its importance, and basis which there were several draft bills, and finally last year in August 2023 we had our Digital Personal Data Protection Act that came into existence. The act is very, compared to the earlier versions, it is very slimmer, typically to speak about, but it has its continues to maintain. It has actually captured some of the Eastern countries, some of the languages. So specifically, when we look at consent is primarily used as a legal basis of processing, and some exceptions for certain reasonable purposes of processing, such as like employment and other law enforcement authorities, still continues to hold. So now when we look at these things, we look at how Article 21 of the Indian Constitution and enlighten the need for right to life and personal liberty also constituted to have privacy as one of the key core component, as part of the judgment, 543-page judgment that was delivered as part of the Aadhaar KS Puttaswamy judgment. Now, while this was happening in India, we also had a very stringent regulation that came into existence, which has been the buzzword and which was also instrumental in many countries looking and revising their current regulations in line with international standards. And that is none other than the European GDPR, which it stands for General Data Protection Regulations. Today, it's no more a regulation alone. It has become a framework like any other regulation framework, such as like the generally accepted privacy principles or your OECD guidelines or APAC guidelines. GDPR has become a standard for organizations to adopt. Is because, as the panel member clearly highlighted, it also constitutes in the sense is because of the human rights component legislation. As Dr. Professor Rekha clearly identified, the rights that have been enshrined as part of the Universal Declaration of Human Rights or the European Commission of Human Rights, the comprehensive nature data was captured, the European sense, very much differs from the US sense, because US is more sectoral in approach. I mean, you look at every sectoral has its own legislations, and each of these regulations practice which is limited only to that particular sector, which is also has gone through a tremendous change post GDPR, with the first state, California, adopting its comprehensive legislation in GDPR. We had after even the Malaysian regulations post to 2010, the Data Protection Act goes back to 2010. There were a lot of amendments or changes that have been brought, and we look at Philippines implementing rules and regulations on the Data Processing Act that was there in 2012 to adopt GDPR equal standards. So today, what is happening and what is the real way that it's taking place is we are looking at a harmonious way in which, irrespective of the different culture and everything, we are looking privacy as a most not only to a particular country or a country state. Privacy, because of its uniqueness, it is trying to approach in many of the jurisdictions in the way how the lawful basis of processing could be agreed, what could be the what should fall within the cross-border data transfers. We can look at back at country like China, which had a governments with the release of the PIPL, which is a Personal Information Protection Law, in way back in November 2021. We are seeing a relaxation of the cross-border obligations that have been imposed on the organizations to limit data transfers. But yes, the one point is in the name of national sovereignty, I think we find every country has its own say and every regulations that they are part. So yes, so that's also one kind of an exception that I could potentially see in the data privacy regulations. Now, how does Indian legislation differ from US and GDPR? So the earlier versions had the language of GDPR adopted, but when we look at the current final legislation that was passed effectively last year, we see there's a very quite distinct difference because we don't see much of the rights available. The rights are limited only to certain set of requirements. The clarity has been there in terms of not to provide many multiple options of exemptions for basis which the organizations or the certain entities can constitute to process data, for any other justification, but more very basis. We do see some legitimate uses, but it's very limited in number. We also see that the other the rights, specifically one of the rights which I'm going to shape the future directions that the Data Protection Board will take is right to grievance. I mean, we look at right to grievance as one of a comprehensive mechanism, whereas to deletion, which is under Section 11 and Section 12 of the TPTP Act, is restricted only to those where the basis of processing has been limited to consent, whereas Section 13 is exhaustive. That means if tomorrow there's an inaccurate data being processed, if AI for use of artificial intelligence and machine learning, where running a model, training model, and basis with certain decisions are taken, will fall within the constitute of any grievance, and grievances are being given a much higher pedestal when it comes to the rights. At least you have a different hierarchical way in which you can exercise your right, but grievance is considered to be one of the very key and crucial factors, and we are looking at organizations or institutions which are collecting and processing personal data. In that line, will have a lot of work and due diligence to be deployed and put in place for effective compliance. Now, when we look at some of the in the AI and ML space, AI and ML is not a regulated market, but every country legislations, including the Indian legislation, the Malaysian Data Protection Act, I think the baseline is when we start using personal data being processed, we have seen that it automatically applies, and that's why there are many countries coming up with changes to be introduced as part of their national legislations to bring within the scope the concept of publicly available information. Earlier, these were exempted and they were never referenced it, but today we see in the new amendments the publicly available informations are also brought within the scope, and we are looking at, once the board is constituted in India, we would look at many rule makings and advisory guidance that the board is where organizations will definitely depend on the board, and as a result of which there could be a significant change in the way how this legislation can shape up. I'm sure everybody is aware GDPR 5 years down the line, from 2018 till now, we are going to complete 6 years. Still, many provisions are very different, and they also every time it's something new. It's the way it's been interpreted, the way you look at a particular vendor. A vendor need not be a vendor to be qualified just as a data processor. They are qualified as a joint controller. They can be qualified as a third party, or they can even be themselves. I think that's going to be the challenge that we are going to potentially see and wait how the laws will place. And in India, accountability is primarily with the data fiduciaries, irrespective of whatever the role the vendor is going to play. And significantly, that is going to expose much of the legal risk. With this, I would like to sum up that India is trying to catch up. The priorities have been put in forth. It has been very clear. And we are looking at rule makings and basis which we are going to see to that as part of either this legislation or through in form of the multilateral trade agreements, we will bring data privacy as one of the key factors. And geo enforcement, many tribunals, many other tribunals which are closely associations which are working will become a very significant play that in the very this privacy rights is going to be balanced. At the same time, there is going to be a cross-cultural entities at the local level. At the same time, at the country level, what all the kind of arrangements is see a harmonious approach, because in the digital world there is no boundary, and it really needs an harmonious approach, not just going within one particular location, but it needs to be a global approach. And I think that's going to be the final we may have to experience as the days come by and see what could be a significant change. This technology and law, which always has this cat and mouse game running between, who is going to catch up first. I think it's going to be from my side. Over to you, Sarah. Thank you.
Thank you very much, Mr. Rajesh Kumar, for the current development and insight on perspective, especially from the India perspective as a developing country, developing country pertaining to data privacy itself. So, ladies and gentlemen, if you have any question, the organizer would kindly invite you to share your question in the chat box. We will collect questions for Q&A session at the end of the session of the three speakers. Ladies and gentlemen, respected speakers, and now we would like to invite our last but not least speaker. Okay, but before that, let me introduce our Honorable Judge Yang Arif, Dr. Muhammad Johanli, who is currently a High Court Judge of Kuala Lumpur High Court, and he was previously an active legal practice and was the managing partner of Johanli and Associates, a medium-sized award-winning legal firm in Malaysia. And upon his elevation, he actually has lectured part-time also in a few local of law schools, namely IUM, LLM in Uniza, University Malaya, the LLB program, as well as IBF in IUM for Master in Islamic Banking program since 2001. So without further ado, the organizer would like to invite our third speaker today, Yang Arif, Dr. Muhammad Johanli. Okay, so Yang Arif, the platform is yours.
Thank you, Dr. Shahira. I really appreciate. And I think the two panelists before me has actually laid down an excellent job of explaining most of the details of PDPA in the respective countries and the law concerning the data protection itself. I shall just do a very brief introduction about the situations or the provisions that we have in Malaysia about data protection as under the law itself. And also I will share with all of you here a bit more than that to highlight the other legal provisions that we have from the other legislations. And I will share with you some of the cases that we have here so far. To be frank, PDPA is still at its infancy, if you would like to say, in Malaysia at this juncture. So we still have a lot to learn, to enhance, to improve, and etc. And lastly, I will highlight to you briefly the proposed amendment that the government might put in place, I was told, very soon now. So I leave with a great idea about what might be in place very soon. Now, can I share screen with some of the PowerPoint that I've prepared for these sessions?
Yes, please, Arif.
Sure, appreciate that. I think we can now see the PowerPoint itself now. Yes, there we are. Now, the brief introduction about Malaysian personal data protection. You understand that this was passed by the parliament in 2010. However, it only came into place or rather implement fully about a few years later, firstly. Secondly, even the drafting of the content of that PDPA Act itself actually took some time and with a lot of consideration in place. So not surprisingly, many of us, when we first take a look of the provision itself, we felt that a lot of things has been left out, so to say. And among others, and one of the pressing issue at this moment, ever since it was been implemented, was this. It only apply to commercial transactions, firstly, meaning it only apply to businesses dealing with commercial transactions, and it does not apply to, or it is not applicable to governmental institutions and governmental ministries, you can call that. So what it means is this. A lot of the businesses outside there, a lot of organizations outside, there's a feelings that they kind of being imposed an additional obligations, bearing in mind data protection was not much of a working culture here in Malaysia prior to that. Although you can actually take action against a party under the law of confidentiality, but to have a specific legal provisions to deal with it, it was unheard of before that. And therefore, at this juncture, many are urging that the government should also be subject to the same obligations of data protections. And for the little information that we have obtained, that will be in place soon by virtue of the amendment to the PDPA Act that we have in Malaysia. Now, briefly, in Malaysia, therefore, data users are, or rather the data are applicable or defined as those employee data about potential clients, business clients, customers, consumers, and data collected or received from clients to be used in the representations, and also data from other sources to be used in the representations. And the PDPA itself actually clearly mentions that businesses and the firms are the data users. However, this is where we actually impose a more bureaucratic requirement over there, whereby there's a requirement for data users to actually register themselves. And then only the law said to be applicable to the businesses customers. Now, just like in other jurisdictions, our PDPA is actually going along the line of the 7 data protection principles. I think I don't need to go into details of that. We are all aware of that. What is crucial here is, at this juncture, the current state of the PDPA 2010 provided the protections of not exceeding 300,000 ringgit Malaysia, which is actually less than 80,000 US dollar. And it may also comes with the imprisonment of not exceeding 2 years or both. Now that really depending on the nature of the data breach itself. Unlike, I think we talk about that, my two fellow panels actually talk about the GDPR itself, which was the key things that I think all the businesses around the world are now kind of bound by it. And therefore, if you compare it with the GDPR, you realize that our Malaysian versions are kind of far more lenient, if I may use the word, in terms of the punishments, and also the applicability is also limited in the sense that PDPA Malaysia is only applicable in, or rather concerning businesses in Malaysia, while GDPR is basically concerning or is protecting the data of all EU citizens, no matter or whatever country or data travels actually. Now, let me quickly do a very brief introduction about personal data. Personal data in section 4 define information that relates directly or indirectly to a data subject, right? And to determine whether the data is personal, one of the few key things that we have to ask would then be, can a person be able to be identified and ascertained from the information obtained and the result of the reasonable inquiry which are made either by the data user or another person? And section 2 of the Act also talk about to whom it is applicable. As I said just now, at this present legislation that we have is only applicable to commercial transactions. And commercial transactions has further been defined in section 4 of the PDPA to any transaction of commercial nature, which includes supplies of goods and services. Now, what it therefore means is this: anything non-commercial in nature would not entitle the data owner from that PDPA protections. Now, the section 4 is actually here. That's what it mentioned about what does it mean by data subject, etc. And I'm not going to go to explain this too much about it, but here I am. I'm just trying to highlight to you, besides, just for a general understanding, besides the PDPA Act itself, we also have imposed this data protections, but of course in its commercial usage, into some other legislations as well. The example that I'm putting up here is actually coming up from the second schedule of the Financial Services Act and also Islamic Financial Services Act 2013, where basically you can say that it is imposing the data protection duty on commercial bankers to actually making sure that they will not by any chance split the personal data of their customers, the banking customers. So this one here highlight to you some other example we have under that second schedule to talk about compliance and the situations when bankers have to deal with data and how they have to in place, have to make sure they will not have any accident disclosure of personal data to non-customers and also non-authorized persons, so to say. Now, done with the brief introduction, because I believe the two panelists before me, my two learned brothers, has already done an excellent job highlighting the principles of PDPA and also PDPA in their relevant countries. And you will realize that we being a part of the Commonwealth jurisdictions, we are not that far apart or different from the relevant legislations that my two learned brothers have shared with you just now. But what I'm going to share with you are some of the cases that we have in Malaysia so far. As I said, we only have PDPA plus minus being implemented in Malaysia for about 10 years now. And what I have here are numerous or the few selected cases I have, and plus minus, including two of the cases that actually have it before me myself. Therefore, I have here 8 cases that I would like to share with you. The first is this Khas Cergas Sdn Bhd case. Now, this is an issue or the data breach when there's a private college operators. These private college operators actually, in processing the personal data of their former employees without a valid certificate of registrations. Remember just now I said that under the Act of Malaysian statutes, we actually require the business to register themselves so that they are been regulated or bound by PDPA. So this is an example of the private college operator processing personal data without getting themselves registered, and meaning they do not have or they did not have a certificate of registrations issued by our PDP commissioner. And that was a big issue of an offense under Section 16, subsection 4 of the PDPA Act itself. And the next we have was sometime back in the, I think, was it 2016, when Malindo Air, one of the local Nodril airlines flying between Malaysia, Indonesia, and Philippines, actually had the issue of a data breach that was in November 2019. In the defense, the act was argued by the airline to be committed by 2 former employees of its e-commerce contractor, and it has nothing to do with the airline. So it actually created a lot of unrest, so to say, some issues of data breach there. And the airline actually pleaded not guilty, and so far we have no much information about what actually transpired after that. This actually just briefly relate us back to the obligations principle that we have under the securities principles, under Section 9 of the PDPA requirement itself. Now, the besides Malindo A just now, we also have a very, you can use the word massive data breach in 2017, where roughly 46.2 million mobile phone subscribers from Malaysian telcos were reported to have been leaked online. The leaked data includes phone numbers, our national identification card numbers, addresses, and other personal details, and also SIM card informations. It was first discovered by the Malaysian Technologies News website, which is a very layman, you can use the word chit-chatting website, loyat.net, when the website received a tip-off that someone was trying to sell huge databases of personal data for an undisclosed amount of Bitcoin on the Loyat forums. Yes, it was way back in 2017, and yet they have already structured it for the, the consideration being structured in using Bitcoins. And other than that, we also have numerous of these, so to say, associations across professional associations, and also numerous other societies, when the data of their members were also being said to be leaked outside as well. And it actually create a lot of massive tracking down to try to track down this, of course, usually this type of syndicates, so to say, they are not onshore. They're usually located offshore, and they perhaps have been using some VPN to cover their identity as well. So, and that's the reason why they would like it to be transacted via Bitcoins. And yes, we also have some along this massive data breach in Sega, you can call that. We also have some of the financial institutions being held for ransom to be paid in Bitcoins in order to make sure that their data or the customers' data will not be leaked. So those actually have a lot of issue over there, and the massive, so to say, data breach actually caused our multimedia communications the commissions actually directed the internet service provider to block the website sayakenahack.com on the ground that he had contravened section 130 of the PDPA because of the data breach out of the incident that I mentioned just now. The leakage actually therefore you can call it awakened many of the businesses here about the obligations and the duties they have when processing and storing their customers' data. And under section 130 is such a huge offense. And as I said, the penalty was up to 300,000 or 2 years imprisonment. And unlawful collection of consent can also fall under the scope of the general principles provided under section 6 of the PDPA, where we actually provide the provisions for that. Now, I also have a case here is actually concerning this case of Kopitiam Asia Pacific, Sdn Bhd. For those outside Malaysia, the word Kopitiam is actually akin to rather businesses that akin to cafe. So it's concerning a cafe when the plaintiff here discovered that there was an article allegedly defaming the plaintiff was being circulated on certain website. And the plaintiff wanted to sue for slander but could not commence action because they do not have any particulars of those responsible for posting such defamatory article. So in this particular case, actually, it was not directly related with data breach, so to say, but it's because the plaintiff really need to have information about the defendants, and they actually commence a pre-action in under our rules of court to actually obtain informations concerning the defendants. And the court, it's a high court decisions. The high court held that the plaintiff applications was not too wide, vague, or akin to a fiction expeditions as contended by the defendant. And as to the applicability of section 8 of the PDPA, the court is using section 39 to say that the court can make orders directing persons in possession of relevant data to disclose it to a third party. So this is what happened here, and because of that, the High Court in this particular case allowed the plaintiff's pre-action discovery. Now, the next that I have here is an interesting case of Chia San Huat and United Overseas Bank Malaysia. Now, this is a case when you can say that it is when the personal data protection work in the reverse. When I say it work in the reverse, because here you are, it's concerning a banking matter when the relevant banking institutions actually had this personal data of these particular customers, and the customers actually have stored in the bank its data together with the signature. Now, some years later, the customers here, Chia San Huat, actually request for a redemption letter or redemption statement being issued. However, the bank officers argue that the the customers here has failed to produce the redemption statement on the authenticity of the signature, right? In other words, the argument here is because the request for the redemption statements was signed off by the customers having a different format of signature. And by virtue of this Schedule 11 of the Financial Services Act, the bank actually refused to release the information without, simply put, without a correct authorized signature. The bank refused to reveal the information about the account to the relevant legal firms, because the legal firms says they represent the customer's concerns, but the bank refused to release the information because the signature was not as per the sample that the customer has lodged in the bank data. So the court held and the court recognized Section 11 of the Financial Services Act that I mentioned earlier, and the court held that the bank is right in refusing to recognize the letter of authorizations, bearing in mind the signature was not the same. Now, the next case is Tan Chong Kian and Yo Tai Chuan. In this particular case here, it was concerning the joint venture agreement that the appellant has entered into with the counterpart. And along the way, the parties agreed that to safeguard the confidentiality, the trust deeds must be destroyed once the project was fully completed. However, after the project was completed, the respondent here was, or rather the appellant, shocked to find that the respondent has used copies of the trust deed to support their applications to third party in the suit. And therefore, the appellant here sued the respondent for disclosing the trust deeds without the express consent. I think for those of us who are in the loop of it, we know this is very serious data breach, so to say. The federal court allowed the appellant's appeal here and granted an injunction to restrain the respondent from disclosing and utilize the trust deed in their possessions. The federal court also ordered that all copies of the trust deeds to be returned to the appellant without retaining any soft copies. And subsequently, the court also ordered the respondents to pay the appellant's damages as assessed by the High Court judge letter. Now, that aside, I also have here the interesting case of Navneet and Sumita. This was actually before me, actually, at the High Court level. The two report has been published based on this. The underlying story of this case is very interesting in that the plaintiff is alleging that his ex-girlfriends have wrongfully utilized his personal data, and therefore he sued the ex-girlfriend and also the best buddy of the ex-girlfriends, because he says that the two of them has comploted together to utilize and manipulate his data. Now, unfortunately, they structured their course of actions, meaning the entire case was done relying on PDPA, our Personal Data Protection Act. And the current state of our PDPA was as such that we don't have any private enforcement provisions. Now, I think for those of you aware of it, it only means that you cannot have it been, civil or the file a case individually by the persons or the victims himself. under our current state of PDPA, anyone unhappy or anyone feel that there was a data leak, they must lodge a complaint with the commissioner and waiting for the relevant commissioner to commence the actions under PDPA to charge the organizations or the persons. However, in this particular case, the plaintiff here did not actually lodge a complaint. He just come straight to the court personally suing these two defendants for data breach. I make it clear to these councils that unfortunately under PDPA, they don't have a case. They just can't take the private enforcement action. They should actually, by right, they should actually sue if they want to have a personal action. They should sue under the common law breach of the confidentiality instead of under the PDPA itself. So there was a very wrong action, course of action being strategized. But unfortunately, under the current stage of our PDPA, private enforcement is obviously not possible at all. Now, let me now come down to the proposed amendments. Now, don't get me wrong, as in, am I so confident about there will be such an amendment? And am I so confident that that amendment or this proposed amendment will definitely be in place? The truth is this: there was such a working committee being formed, and it was actually, there's a working group informed in 2020 by the government, and the committee actually had formulated and come out with this following, so to say, recommendations. And we were told that the relevant ministry has actually taken out the recommendations, and supposedly there will be an amendment to the PDPA being tabled to the Parliament sometime approaching to April or mid-year this year. However, how far this will be ever to be successfully going through, only time will tell. And what are the proposed amendments that will be tabled in that particular table to the Parliament? Well, at this juncture, it's still too premature to jump into conclusions, but let me just highlight to you the recommendation put out by the working groups, so to say. And you have to understand the situation that necessitates this amendment was mainly because our current versions of PDPA is far apart from the GDPR, the UK versions, EU versions, and therefore a lot of things needs to be, so to say, amended in order to, I don't want to use the word comply, but I would rather use the word to enhance ourselves to make it more in line with the GDPR requirements, so to say. And one of the most significant, and I may use the word, the most look forward will be the proposed amendment will now extend the applications of the PDPA to non-commercial activities. So they will amend transaction to mean not only commercial transactions, it can also be in domestic transactions or domestic relationships, so to say. Now, it also imposed direct obligation of data processors, including the obligation to register with the Personal Data Protection Commissioner. If implemented, the data processors will no longer be bound by just the four corner, there's a spelling error there, of their contract with the data users, but can be made liable directly under PDPA 2010. And what else do we have? It also expands the data subject's right to include the right to data probabilities. And under this proposal, assuming that the equivalent parameter under the EU GDPR will be adopted, the data subjects will have the right to receive personal data that they provided to a data user in a more structured commonly used and machine-readable format. And additionally, data subject can also request that the data user transmit the personal data to another data user. Now that will be by an express authorizations. And the personal data must also be poured in a structured, commonly used machine-readable format that's under the proposed amendment. Let me quickly go down, and the relevant organizations dealing with data processing and data storage will now have to, in order to ensure compliance, will now have to appoint data protection officers. And this is actually also more or less following the requirement under the GDPR. If such a requirement is being imposed, which we believe it will be, in the PDPA 2010, some practical issues may arise, including the availability of expertise or experts in these areas and cost implementation of any organizations. But of course, that will be the key considerations for the relevant ministries to look into that. And also impose data breach notification requirements. Now, I do believe that all of us are aware of this fact that in the new millennium, we are always talking about self-governance. And this part of it now come up with the idea of if any organizations have internally found out that there is a data breach in their organizations, they now have to voluntarily notify the commissioner. And from there, the commissioner will work hand in hand with the relevant organizations to mitigate the risks and to mitigate the negative impacts that could be arising out of that breach. Now, the consent also, the definition of consent will be modified, so to say. I won't be able to give you too much details here because at this juncture, it is still in the drafting stage, you can call that. And the other thing is this: we used to have, we still have it under the current version of the PDPA under Section 129, Subsection 2. There is a proposal that we will remove country whitelist under Section 129, Subsection 2 of the PDPA in order to facilitate cross-border transfer of data. Right? Currently, Section 129, Subsection 2 states that personal data shall not be transferred outside of Malaysia unless to such place as specified by the relevant minister. However, at the time of this presentation, there have not been any application or the publication on the whitelist countries by the minister, but there was a proposal to remove country whitelist in total. Now, additional mechanism that will be taking place or that will be proposed as part of the initiative is the APAC cross-border privacy rules systems. And this particular CBPR systems is a government-backed data privacy regime. And through these particular systems, organizations are able to be satisfied to demonstrate their compliance with internationally recognized data privacy regulations. And it actually will facilitate cross-border data flows. Now, to obtain such certifications, organizations must then implement data privacy policies consistent with the APAC privacy framework. And of course, as I say, that was a proposal. How far, whether that will be implemented in the amendment this round, or it will be in a subsequent amendment, because it will take quite a lot of legal infra to be ready and in place for that. And therefore, it might not be this amendment, it might be the subsequent amendment, or we have no idea at this moment. But that was actually in the pipeline being proposed by the working group, so to say. And the interesting part that I like about the proposal put out by the working groups is this: establishing a do not call registry, and which is a service that allows data subjects to opt out of the receiving unsolicited telemarketing calls. Trust me, for us Malaysian, once that registry is been how should I say, established, we will feel that it is God sent. After being harassed non-stop by so many of these unsolicited telemarketing calls, even at night or even during the weekend, I do believe that that will be sensible, apt, and wise decisions to have it in place. And it is hoped that this will be under this coming round of amendment, and allowing data subject to actually bring a civil action against data users. As I said, the case that I have just like highlighted to you just now actually showcase that we still have a lot of unfortunate situation in case that the data subjects would like to bring civil claim against data users. We just don't have any provisions for it at this moment. And therefore, the amendment really depend on the conclusions that the proposals that we should have such a mechanisms in place for it, and also for the private enforcement actions. Right. So to conclude briefly, we in Malaysia still PDPA in Malaysia is still at its infancy, and please bear with us. We still have to have, I don't use the word lots of amendments. We still have to have some amendments in place in order to make it more relevant and more practical, so to say, to the millenniums and to the current business culture, so to say, and also to keep ourselves up to date with the needs of data protection worldwide. I think that will be it from me, and thank you for the lending me your ears, and wassalamualaikum. And let me now pass back to Dr. Shahira to continue with the next part of the forum today.
Okay, thank you very much, Yang Arif, Dr. Muhammad Johari, for interesting insight on the current development on the PDPA itself and the what we call the pipeline. As what I've heard, is going to be tabled in Malaysian Parliament this March. So we will see what would be the next progress. So, ladies and gentlemen, on behalf of the organizer, we would like to thank all the three speakers. And as far as we can see, there are a lot of questions already being collected. And if I can start with question number 1, we come from the Faculty of Law, Manipal University. The first question, it is open, I believe, to all the speakers. The first question sounds, does the municipal legislation will be able to curb global data privacy issues? So that is the first question. If I can read 3 questions first and open to all the speakers. Number 2, are there any cloud storage in WhatsApp or is agent to the data protection? So it's regarding what we call WhatsApp, okay, and its agent to the data protection. The third question, does the monopoly of certain companies in the digital landscape determine industry standard for term and condition and privacy policy for other websites? Therefore, I'd like to invite perhaps the first speaker and then the second speaker and the third speaker. Shall I repeat the question or?
Yes, please, because it's not clearly clear.
Okay.
Sorry.
So, Doctor, the prospective speakers, there are 3 questions. Number 1, does the municipal legislation will be able to curb global data privacy issues? So that is the first question. The second question is about whether there are any cloud storage in WhatsApp application or it is an agent of the data protection. So that is the second question on WhatsApp and the issue of cloud storage in WhatsApp. The third question is about, does the monopoly of certain companies in the digital landscape determine the industry standard Okay, as we can see, some companies might put the term and condition and privacy policy for other websites. So these are the first three questions that would like to be posted to all the three respected speakers.
Okay, if I may go about the municipal legislations. So typically in India, we don't have separate municipal legislations. We find that in some countries like China, I think even in Philippines. However, the central omnibus legislation that applies most to the core. Your second question was on the WhatsApp cloud storage. See, WhatsApp is typically that there are, it depends on what else. So it's all stored on Meta servers. So, and it's all on cloud only. The only thing that they extend the end-to-end encryption. Third question was in terms of, if I could recollect, monopoly.
Monopoly, yeah.
Yes. See, without taking much about getting into the details, but yes, it doesn't remain so. But if you look, for example, the monopoly that today we see in much of the digital technology evolution is companies like Meta, Google, and stuff. But many times we also see changes in the regulations. We also see changes in the way how new regulations are brought in as technology evolves. With, for example, Meta, Google, they face a significant penalties for non-compliance and stuff. So I would not use industry practices as one thing, but just a monopoly entity is little outside the box, and I don't see that is anyway going to determine. Some best practices can be incorporated, and sometimes that best practices could be adopted by many of the organizations. But I don't see that specifically that many of these big giants decide what should be. I'm not talking in terms of the lobbying during the regulation coming in. I'm talking in terms of a practice or adoption. I think I don't significantly see any such impact, such monopoly markets is trying to create it.
Okay, thank you
This
very
is
much.
my thoughts. Yeah.
Mr. Rajesh Kumar. Okay, thank you also to Dr. Ella Gren who has posted the question that has been collected from the Google form registration. Therefore, perhaps Dr. Reka, yang Arif, Dr. Muhammad Johan would like to respond. The question are in the chat box. I've read the three earliest questions. Okay, we talk about the municipal legislation. Secondly, is about cloud storage. The third question is about monopoly of certain companies. And so especially about the terms and condition privacy policy.
Dr. Reka?
Okay. Okay, thank you, Dr. Lee. Yeah, maybe I will answer it first. Okay, for the first questions about the municipal legislation that will be able to curb for the global data privacy issues. Maybe I've been make some if we talk about the is there any standard or legislation that can make for the transition that must have, because if we are as the data protection obligation, they must under PDP and PDPL, GDPR, and all of the regulation. So if we are a data controller, if we are the data processors, so they must have any reasonable for technical organizational step if we want to protect for all of the personal information that we hold. So if the global data that have been breached for the response that have been focused on reducing for the impact, I think they must have a reasonably for one steps. So there must be some of the limit consequences. So if there are some data breaches that have happen for the person, I think the quick response that it can be reduced for effective individual that can suffering for all of the harms. So we can take any lessons for is there any global or reputational damage for the data that have been controlled, and they must make any some system that can preserve and can build for the public trust. So I think if the person that have made some controlling for the data privacy issues, I think municipal for legislation that it can be able for that. And then is there any code storage in WhatsApp or against to the data protection? All of the regulation is having make any obligation that if there are the type of the data for the confidentiality, for the integrity, for the availability, so it have been made any authorized and accidental for the disclosure of the access of the personal data. If we say that's the there are some reason about some equipment failure or some human error, the hacking attack, and etc. So if there are the processor, if they are the controller of the data, I think they must be provided for the conditions such as the notification requirement, such as the some cases for the unlikely risk, or there are some controlling that must be notified when the breach for the regulator. So if they are filled with the high risk, I think the application must make some communication for the personal data breach for the data subject. So if you are asking about the is there any cold storage, I think they must have that for the protection for the data. And then about the monopoly for the certain companies in digital landscape for the demand standard for privacy policy for the other website. I think there we must we must take any some solution based on the baseline for the data protection. Some Asian framework for the personal data protection is say that if we want to take or make some basis for the identification, if we want to take some to-do deletion data protection, so there must be some relationship of the parties. So the relationship cannot be used if there are some monopoly of that made by the person or the corporation that's made for the persons. So I think it can make any necessity for the ensure that the personal data that have been transferred for the basis, it must be afforded for the low level of protection. I think we must have any equivalent for the guarantee that made by the sometimes with the data importer or from the another should be allowed if the importer must come compliant and etc. Otherwise, I think for the basis of the concerns of the data subject, it must make by the safeguard made by one of the persons. So I think there are no monopoly for the data protection. I think that for my answer. Thank you.
Thank you very much, Dr. Rika. Dr. Muhammad Johari would like to share your perspective.
Yes, I think from the list of the questions, I will pick some of them that I think will be more relevant to Malaysian side, so to say. Obviously, I'm not representing the commissioner. I'm not the commissioner. I mean, but I'm just sharing some of the knowledge that I know about it. Like the first one, does the municipal legislation will be able to curb global data privacy issues? It will only be able to do so if the scopes of the legislations have been drafted to actually enable cross-border enforcement and the cross-border outreach of the law itself. And that's the reason why if we have the one that I highlighted, the working group proposal about the Asia Pacific working group together on this, it will be interesting in the sense that, we might not need to go through the rest of the world, but at least for Asia Pacific, if we can all have the cooperations between all the relevant countries, then to the extent we could be able to corrupt data breach outside our jurisdiction, but still within the Asia Pacific region. So that will be excellent by itself already. right? So let me go down to the interesting question about monopoly of certain companies in the digital landscape. Now, it actually drew, I immediately got my attention on that question just now because competition law is my PhD, actually. So the moment I heard about the word monopoly, that sounds interesting. But yes, I agree with Dr. Eka that there is no such thing called monopoly in data processing and so to say, right? And as an ex-practitioner who really involved in a lot of drafting for organizations, including their internal policies or PDPA and all those, I can tell you this. The fact is this. Maybe one particular big organization might have their standards of data processing. Remember, when you click on the website to them, they will ask you to agree or not agree to process the cookies and everything. Now, not everyone, you see, all the organizations will actually have their own versions of that. The only thing is this, why is it at the end of the day, it will appear as if one or two of the big ones set as standards for the entire industries? It's because after a while you realize that we are all coming down to the same way of the principle. Remember the 7 principles that we have to safeguard the data that we process. So it appears, therefore, the terms and terms and conditions of company A and company B's appear to be the same. And you may say maybe company A was we call it the prime mover. They were the first one in the industry that started that the consent and to what extent they can process the data. So it somehow appears, therefore, companies A is the one that dictate the whole industry standards. It is not in the actual sense. It doesn't go that way, right? And trust me, most of the organizations will actually engage their own lawyers, their own counsels to draft whatever that has to be covered in that little clicks that we click. Are we consent or we agreeable to it or not? But it's just that it appears, therefore, one company is now setting the standards of the entire industry in the TNC. Actually, it doesn't come by way of this monopoly or whatever collaborations or illusions you can call that. But no, it's just a matter of because we all have to go down to those principles of data safeguard and security that we have to really, bear in mind for that. Now, let me quickly go down to I think the other question that might be a bit more relevant to us in Malaysia, related with Malaysian's law, is about number 6. Why there is no consolidated legislations regarding data privacy as compared to EU legislations? Now, I think the answer to that is this. In most of our jurisdictions, all these different legislations will actually be under the purview of different ministries and different pieces of law. So if you want to have a consolidated legislations to override and to have across board to apply to everybody applications of data protection, it might take a long way to take away this power from the relevant ministries and the power of the different commissioners and different tribunals, so to say. And that's why it is always very challenging to do that. In the EU, it could be made possible because everything in the EU is talking about centralized, and they can therefore easily reach that part and that level of it. In our countries, all of our countries here, I think that would take a long journey to go. If you talk about federations, it might even take a more challenging and more or long wind way and road to achieve that target. So I think those are the few points that I think it could be able to share some idea about. And I pass it back to you, Dr. Shahira.
Thank you very much, Arif, Dr. Muhammad Johanli, for the insight, especially about consolidated legislation and as well as data privacy compared to EU legislation. Okay, so if ladies and gentlemen, perhaps question number 4, how Indian data privacy space differs from Europe and United States. And number 5, what are we expecting from the DPDP Act accompanying rules? So perhaps we can hear also from Indonesia as well as India. How about consolidated legislation compared to European Union? And question number 7, what are the biggest challenges in India will face with its new legislation from the countries who have had laws on privacy for a longer time? And finally, the question by Samina Khan, also from India, about the scope of Indian digital personal data protection, which have been answered by Mr. Rajesh Kumar, but perhaps I should read the question again. Whether it applies to online violence against women also, or does the act applies only to protecting the personal data related to goods services? So I'll open the question to Mr. Rajesh Kumar.
Okay. Thank you. On mute. Okay, that's fine. On the fourth question, which is typically on the how Indian data privacy space differ from Europe and USA, as we said, see in the Indian legislation, I think even though we had tried to adopt some of the GDPR related requirements, but it has its own. There are areas such as consent manager that has been introduced. We also look at some special provisions in terms of significant data fiduciaries, where the comprehensive approach that is very common across for all European countries or sectoral approach has been removed, and we are creating requirements and rules based on certain categories of data fiduciaries that has been aligned. We had many categories in the earlier sections, but this time it has been executed generic data fiduciary role, and plus also we also have the significant data fiduciary for which rules are yet to be published. What are we expecting from the act accompanying rules? We are expecting a lot of guidance because it's a beginning. There are a lot of industry applicability and other issues and concerns that will emanate from the legislations, especially in the area of consent. We may have multiple queries in terms of notice. Typically, what could be those requirements? Some more clarification, but this is a work in progress. We are not seeing any much bigger changes for now, as long as and the rules, I think it was supposed to be published last month for public consultation for 45 days, but it's been put on hold due to election and other norms. But we can expect once the board is established, once the rules are set in terms of what will fall under the significant data fiduciaries and rules around specifically around some of the exceptions which might have been approached specifically in terms of certain processing legal basis, because today the legitimate use has been very left at a high level. So we are looking at some changes and including the exceptions. Just like Singapore and other legislations, the law applies only to personal data of processed belonging to data principals originating or to whom the services are provided in India. The law has a extraterritorial jurisdiction, but still there are scopes have been not very clear in terms how the enforcement will take into effect. So these are some of the requirements that we are seeing, how if the DPDP Act the rules can be emanated, as well as once the board constitution happens, how the advisory guidelines may fall through. Why there is no consolidated legislation? Yes, even in Europe, it was not consolidated. Even if you look at the current GDPR, the intent was to harmonize, but there are derogations available for each country to adopt. So you may still see the changes in certain countries. The child's date of birth could be 13 or it could be 16. So there are still differences to it. But what aspects the difference it makes is it has at least initiated the approach compared to many things that were there as part of its predecessor, the EU directive. But some of the administrative controls, like the one-stop shop and other requirements that you potentially see after Article 50 of the GDPR, that's where the authorities coming and putting a common mindset not just only when organizations file for BCR, but also handling some of the entity matter, like the Clearview matter, where the facial technologies were used in terms of dark patterns, many things coming in. Now we are also looking at AI as a separate legislation. In many other countries, we have only standards, guidelines, and regulations being published, but a specific law like EU AI Act, there are differences to it, and bringing it to a consolidation, it's entirely based on the cultural value, the trade importance that the particular country may provide as kind of its priority, and some kind of leeway that can permit where countries can. So we will continue to see differences, and probably these differences will be arranged or agreed as kind of certain multilateral trade agreements. So, that could be the only difference, what we can see. But consolidation will be very tough at the ground level. Last but not the least, what are the biggest challenges India will face with its new from the countries who have had laws on privacy for longer time? I don't think there is any potentially. I don't see it as an impact. Typically, unlike other legislations, when legislation comes, there's a huge business around it. For example, when HIPAA came back in with the omnibus rule in 2013, for the organizations to meet compliance with the HIPAA obligations and meet compliance with the Obamacare and other requirements, the cost of the industry, the billion, it was almost close to $90 billion was the industry to make sure compliance. So I don't think Indian legislation has that kind of forte. It has actually opened up rooms for new entities and new businesses in the form of, say, you have a data audits. Even it brought in a new concept called as a data trust score in the previous version, which we don't find it here. So I think audit and other industries are going to evolve. There's a new industry called consent manager that can evolve, which today in India, we already have it as part of a data aggregator in the banking field. We do have that. So I think that would be, it could also find a solution to some of the biggest problem that any country has, the hardship in maintaining and making sure, justify that the consent was taken for the right choice. I think that could be one of the answers. That is how we are foreseeing how the Indian legislation could have a bigger change. But I don't see potentially impacting any other countries because inclined contracts and other things that we may execute by our Indian IT service providers to other customers across outside the board, they are exempted from the DPDP Act, and that except the technical safeguards and the retention, which continues to remain similar to Section 72A of the Indian IT Act. So from my viewpoints, personal viewpoints, I don't see it has any potential impact that it could impact other countries. Probably it could also be a good as long as it is shaped in a very effective way.
Okay, thank
These
you
are my
very
thoughts.
much, Mr. Rajesh Kumar. Since time is not in our side, perhaps a quick conclusion from Associate Professor Dr. Reka Dewantra, Yang Arif, Dr. Muhammad Johan on this important forum.
Okay, thank you, Professor, for the concluding remarks from my last sentence. If we want to make any data protection or data privacy in our country, I think the Asian state, because the data privacy in Asian is very pluralism rather than data privacy in UK or in another Europe countries. So if you want to make any data protection, if there are some third party that will involve for the control, I think they must receive for the personal data that the customer and provide some evidence for unauthorized disclosure. So as the controller's data, as the processor data, they must be present with clear evidence for the confidentiality present. There can be no doubt that the person must be aware of the problem that can give by the or can be impact by the person that use of the data privacy. Thank you.
Okay, thank you very much, Dr. Reka. Yang Arif, Dr. Muhammad Johan.
Quickly, I think data protection is still a new culture for us. That yes, alhamdulillah, after about 10 years of it in Malaysia, I think it's slowly getting the momentums that I think businesses are getting more serious about receiving data and storing and safekeeping the data of the customers. But it would still take some more need to be done in terms of law, in terms of the enforcements, in order to reach the next level as in other established jurisdictions. And of course, the best that the law could do is only to provide the provisions. At the end of the day, is the educations that will actually make it a reality. So I think on that part, the Malaysian side has done a good job in trying to create the awareness among the general public and also among the businesses about their duty and responsibilities of data protection. But as I say, it will gradually become a part of our corporate culture in order to have it been, so to say, safely safeguarded and stored, so to say, and not being abused. At the meantime, we just have to bear with some of the harassment that we have received every now and then. But yes, I think we are actually having a good start already, actually. Right, so I think that will be it from me. Thank you, Prof. Let me pass it back to you, Dr. Shahira. Prof.
Thank you very much, Arif, Dr. Muhammad Johan. Perhaps last final conclusion from Mr. Rajesh.
So from my side, I think my esteemed panel members have already said. But I would like to probably a request. See, what we typically see is as laws change and evolve, we are going to definitely see technologies evolve and change. I'm purely from a legal background, but today is a need of the hour that if you wanted to make sure you're compliant, you need to make sure the data needs to be protected. There is a very essential need for legal and technological minds to combine and join. So the area of privacy engineering is evolving, where multiple areas of research, privacy by design, which used to be a best practice in the past, which was coined by Dr. Ann Kawoki, and today it's one of the legal and mandatory provision that you see in legislation like GDPR. We are also having to see a legislation called the the AI Liability Act coming into existence. So in the New York, we have already seen bias audits being mandated in case if you use a tool for any automated employment purposes. So what I see is probably the increasing need of the techno-legal understanding or solutions is going to be the very key. And I think more hormonal approach of many collaborations and consortiums across represented by within the countries or within different colleges. I think that would be the need of the hour, and that would be my closing remark, that that's something which we are going to see in the next 2 to 3 years.
Thank you very much, Mr. Rajesh Kumar, and this ends our forum today. But before I pass to the MC, in conclusion, what we can say that reform is necessary to ensure better protection for the rapid growth of digitalization in line with the protection of data privacy. On behalf of the organizer, Dr. of Sharia and Law, would like to thank the National Law Unit in collaboration with Faculty of Law from Manipal University, Dr. Ella Gorian, Associate Professor, Dr. Hazmi, Dr. Nur Zuhaida, Dr. Amalina, as well as Dr. Farid, in this organizing the forum on the digital as well as the data protection. So on behalf of the organizer, I'd like to apologize for any shortcomings. As we can see, time flies very fast. We did not realize almost 2 hours and a half. And we believe that there are many legal issues that we need also to discuss. Inshallah, in the next forum, inshallah. So again, thank you very much on behalf of the organizer to all the respected speakers today in sharing their suggestion and also what we call perspective. So I'm Shahira Abdul Syukur, signing off as the moderator for the forum today. Would like to pass to the MC today, Mr. Imran.
Okay, thank you, Dr. Shahira. Ladies and gentlemen, in order to capture this wonderful moment in our memories, we would like to invite the guests of honor and all of us present here to have a photography session together. So you can open your camera, feel free to open your camera, and uh, we'll give like 30 seconds for everyone to be ready. And then Amjad Majri will be the one who capture their photo.
Yes, everyone can prepare maybe a minute. So I think there's no one open camera. So okay. Right. Yes, so let's take first picture. So 1, 2, 3. Another one. Okay.
Thank you.
1, 2, 3, smile.